are the changes that have been introduced by this new act that was recently passed in respect of the arbitration landscape in Nigeria? And what are the implications of these changes strictly for arbitration in Nigeria? Thank you.
Princess, thank you again, and thank you to the MBA Garki branch for organizing this session. Like I said, I'm really looking forward to the discussions, and I'm really happy to see so many people have joined, including some of our very, very dear colleagues who also played a role in ensuring the enactment of this new piece of legislation. So essentially, the Arbitration and Mediation Act primarily aligns Nigeria's legal framework to the most up-to-date version of the ancestral model law. So it potentially positions Nigeria as a very competitive seat on the African continent, and eventually what we hope will be a very competitive seat worldwide. I say potentially because the act in and of itself isn't sufficient to do so. There are other key factors that we have to ensure are in place, and hopefully we get a chance to discuss what those are during the course of this webinar. Now, in terms of the key additions, well, there are several, but let me just highlight a very few, the ones that have generated the most discussion. I think perhaps the one that has generated the most discussion is something called the Award Review Tribunal. Now, typically after the publication of an arbitral award, several options are available if there isn't voluntary compliance with the award. So one, the aggrieved party might bring an application to challenge, and the successful party might bring an application to enforce the award. The problem we were having in the Nigerian context is that increasingly arbitration was being seen as pretty much the first step to litigation proceedings. So the efficiency you would have in the arbitral process will then lose all its effect as soon as it has contact with the courts. So for instance, let me just give it to you in context. We conducted a study as to how long it takes on average for arbitration-related applications to go through the courts. And if it goes from the High Court all the way through the Supreme Court, you're looking at an average of about 10, almost 11 years. So about 1 year, 9 months in the High Court, going up to just over almost 3 years at the Court of Appeal, and anything from 5 years upwards at the Supreme Court. So the idea behind the Award Review Tribunal was to give an alternative to challenge proceedings before the national courts. And this provision, firstly, is an opt-in provision, so it's not mandatory. If the parties want to use it, they have to indicate so in their arbitration agreement. And if they do opt into it, then rather than submitting your challenge proceedings to the national courts, you will submit it to a second-tier arbitral tribunal. The advantages are that you have the same expert framework that determines the substantive dispute that will also now determine your challenge application. And they have to endeavor to do so in a 6-month time frame. So it is significantly quicker, or we hope it will be significantly quicker than what you would typically have with court proceedings. Yes, there are drawbacks or potential drawbacks to this, in the sense that there is a danger that it will escalate costs. There is a danger that it will also escalate times and the complexity of the dispute. But you have to sort of realize that the Award Review Tribunal is not for every single dispute. So if you have a relatively simple claim, then this might not be a provision you would want to include in your clause. So it's really down to the parties to do an assessment, try to think ahead proactively as to whether they would benefit from this in terms of the additional costs, the additional times, and also look at the trade-offs as to whether what would be more beneficial in terms of submitting your challenge to the national court or to the review tribunal. So another key addition is emergency arbitrated proceedings. So emergency arbitrated proceedings allow you to seek urgent interim relief from the tribunal before the constitution of the tribunal itself. So what used to happen before is if you had a very urgent relief and the tribunal has not been constituted, if it's a Nigerian-seated arbitration, then you would have to go to the courts. The problem was that there was a very, I don't know if to call it awkward, but there was a decision involving Econet many years ago in the Federal High Court, where they brought an application for urgent interim relief. And the court rejected it, saying that because you do not have a substantive claim before me, I don't have jurisdiction to grant you interim relief. Essentially saying that interim relief is not a cause of action in and of itself, but is tied to a substantive claim. So that created a very confusing framework as to, oh, well, can I approach the courts, or do I have to wait for the constitution of the arbitral tribunal? So this new legislation takes care of that. It expressly says that you can go to the courts if you want to, but to the extent that you want to keep it again within an arbitral framework, you can engage the emergency arbitrator provisions. And there are very, very strict and very short timelines in which this must occur. The emergency arbitrator must render a decision within 14 days from his or her appointment. The other very significant one is third-party funding. At least conceptually, the Act now recognizes that third-party funding of arbitration is a possibility. And it does so by abolishing the torts of maintenance and champity. As you know, those torts prohibit the funding of a claim if you are going to get a benefit from it. So the idea behind it is it's to stop frivolous claims, to stop claims that are purely meant to harass. And there was a question mark as to whether third-party funding offended these torts. So the Act abolishes those torts as it relates to third-party funding of arbitration and also arbitration-related proceedings. The Act also recognizes that you can claim the costs of third-party funding, and I believe the Act also attempts a definition of third-party funding. Now, there are other introductions. I don't know how much time we have, so let me just do a time check with Princess to know if I can still proceed, or if you are okay with my highlighting. I think those are the major key introductions, but there are things like interim measures, enforcement of interim measures, the default appointing authority. It has a bigger role for Nigerian arbitral institutions, and I know Professor Onyema is on the call, and she's very passionate about increasing the role of making meaningful contributions for arbitral institutions on the continent. It introduces the concept of arbitrator immunity. It limits the grounds for setting aside an award. So, for instance, that very nebulous ground of misconduct is no longer part of our legal framework. And also, it takes care of the issue of limitation periods. Many of you might be aware of that decision in city engineering that caused a lot of confusion as to when you would have to conclude and enforce your arbitral awards relative to the date of when your cause of action arose. So the new Act takes care of each and every one of these things with the intention of positioning Nigeria as a competitive seat. So I'll pause there for now, and just to ensure that we make very good use of the time. But if there are any questions, please feel free to put them in the chat.
Okay, thank you for the contribution. I was able to note a lot of things down. I was able to note the emergency arbitration relief, the third-party funding. Thank you. This is the next question, Mr. Bagshaw. How's the dispute resolution outlook as presented by this Act? How's the outlook in comparison with international arbitration laws? Does the Act and the provisions actually meet relevant international arbitration law standards, or just let us know your thoughts on this?
Princess, it's an honor to be able to offer some thoughts on the Act. I should say I defer to my learned colleagues who are both Nigerian scholars and also were involved in the process of drafting the Act. But I hope I can offer some thoughts from an international perspective, and also as someone who has seen on quite a few occasions proceedings in the Nigerian courts alongside proceedings in other courts and arbitration. And I've certainly experienced the complications that can arise when different legislative regimes collide and different courts are dealing with the same case at the same time, sometimes in different ways. So it was a real excitement to me that the new Act received its assent when it did, and to see the provisions of it which had been adopted. And that was for two reasons. The first reason is that in a number of respects, as Mr. Isaiah was saying a moment ago, the Act brings the Nigerian legislative provisions on arbitration into line with what have emerged as very well established international standards of law on international arbitration, relating both to the process of international arbitration where the seat is Nigeria, and relating to the involvement of courts in the enforcement of awards and their involvement in cases even where the seat is not Nigeria. And just to touch on some of the ways that the Act has successfully achieved that. Firstly, let's mention the question of enforcement of the arbitration agreement itself, because sometimes overlooked is the fact that under the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, there is a provision not only on the enforcement of awards, but also on the enforcement of arbitration agreements. And this is a hugely important provision for the respect of parties' choice to arbitrate. And the new Act, in several respects, robustly enforces the choice that parties have made to arbitrate. So the first thing it does is it makes it explicitly clear that an arbitration agreement is irrevocable, that it can't be revoked or departed from by a party who has changed their mind about arbitrating. The second thing that the Act does is to give clear provisions on what is required to make a binding arbitration agreement. And those provisions broadly fall into line with the provisions of the UNCITRAL model law on what arbitration agreements must include. The new Act in Section 2 says that the arbitration agreement must be in writing, but it makes it clear that that includes its content being recorded in any form, and whether in a separate contract or as part of the contract within which it is contained, that those communications can be electronic. There isn't need for physical writing. So that's very clear. The Act goes on in Section 5 to provide for what should happen if a court in Nigeria is engaged in a case where one of the parties asserts that there is an arbitration agreement. And as I understand it, this is a more robust provision than previously existed under the old Arbitration Act in Section 5 of that Act as well, which provided or was interpreted as providing a discretion for the court to decline to stay court proceedings in favor of arbitration, and also a requirement that the court had to be satisfied that the applicant seeking to stay the proceedings was willing or ready to proceed with the arbitration itself. Those requirements are removed from the new Act, and the new Act falls into line with the international standards of other legislation by providing that the court will stay proceedings when they're commenced in breach of an arbitration agreement, unless the court finds that the agreement is void, inoperative, or incapable of being performed. Just to pause here and note that, as Isaiah observed earlier, all legislation requires interpretation. All legislation requires courts that apply it in the spirit in which it is intended. And this provision, the provision equivalent to this in the Arbitration Act in England, has produced quite a lot of debate over whether or not the court should actually conclusively decide whether the arbitration agreement is void, inoperative, or incapable of being performed at the time that it's requested to stay court proceedings, or whether, if there is apparently an arbitration agreement, the court should say this issue should not be resolved now, because we should allow the arbitrators in the first instance to exercise their judgment on whether the arbitration agreement is valid or not. That being part of their competence their entitlement to resolve in the first instance their own jurisdiction. Hopefully this new act in this respect will encourage courts to follow the approaches that have been taken in other international jurisdictions, not just England. There is a lot of other guidance around the world for Nigerian judges potentially to refer to when referring to this act. In particular, Singapore has a very substantial jurisprudence in this regard, and other jurisdictions have been following, for example, in India, that have similar laws. So in the enforcement of the arbitration agreement, this act certainly brings Nigeria's law up to the standards of other gold standard international arbitration laws, and it gives the judiciary in Nigeria an opportunity to apply it in a way that reflects the spirit of the New York Convention. Just to mention then the other end of the process, as it were, the enforcement of arbitration awards or challenges to arbitration awards. The Act, as Isaiah Bozimo said a moment ago, it follows the UNCITRAL model law in its most up-to-date form in terms of the wording of the sections on the enforcement of arbitration awards and the challenges that can be made to arbitration awards. The key takeaway about the Act is that the grounds which are provided in the law for challenges to awards mirror those in the UNCITRAL model law. There is no longer any general ground for challenging awards based on arbitrator misconduct. And it can be taken from the adoption of this text that the legislative drafters intended, or we can expect that they intended, that the provisions in section 55, which provides for challenge, will be applied quite restrictively so as to set out what in the English courts has been described as a complete code for challenges to awards, which doesn't leave a residual discretion to judges. Because I'm sure most people watching will be familiar with the text of the New York Convention, which includes in its provisions a requirement that courts must enforce arbitration awards. They may refuse to do so when the criteria set out in that section are satisfied. So rather than giving a general discretion to refuse in any circumstances, what the law, the new Arbitration Act and the UNCITRAL model law on which it's based, what they do following the New York Convention is to allow the court to enforce any award and to give a discretion to decline to enforce only when the conditions are satisfied. And that spirit of highly restrictive discretion to the court to refuse to enforce arbitration awards or to set them aside under section 55 of the new law is really important in making Nigeria's law in line with other states' laws on international arbitration. I will mention third-party funding because in this respect, undoubtedly the law in Nigeria has very much come up to date. The new Act for the Avoidance of Doubt abolishes championship and maintenance in relation to arbitration, so it makes it clear that those are no barriers to the concept of third-party funding. And it also goes significantly further than many arbitration laws in providing a significant amount of guidance on the question of third-party funding in section 61 and 62. In particular, there is specific provision for the disclosure of third-party funding, which must be given when one of the parties to an arbitration seated in Nigeria is in receipt of third-party funding under a qualifying agreement. That's extremely useful because that's been a very vexed subject in other jurisdictions. A lot of courts have had to grapple with the question of whether third-party funding has to be disclosed, and if so, what has to be disclosed. So the Act can be commended for trying to give clarity in that area, which is a difficult area which comes up when third-party funding is an issue. I think it's right to mention the Award Review Tribunal, as Isaiah Bozimo did a moment ago, because it's such an interesting provision. There are other matters on which the law either follows or goes further than and provides greater clarity than other international pieces of legislation, including those on emergency arbitrators, which again does not appear in every international law, but provides welcome clarity to parties arbitrating in Nigeria that emergency arbitrators is something that can be done and is available to arbitration institutions in Nigeria in cases where the urgency calls for prompt intervention to support the resolution of the dispute. But finishing with the award review tribunal mechanism, this is particularly interesting for English lawyers and those who follow English law, because many of you will be aware that currently the English Act is under review. The Law Commission of England and Wales is reviewing the English Arbitration Act. And one of the great questions that they are grappling with is the standard of review of decisions of arbitrators by the courts, particularly when a challenge is made under Section 67 of the English Act on the basis of a lack of jurisdiction. The question is a very difficult one, because various commentators in England have said that the courts must have complete power to review and revise questions on jurisdiction made by any tribunal on the basis of what is called in old-fashioned language the bootstraps argument. Arbitrators can't decide that they have jurisdiction if they're wrong, because if they're wrong, there's no basis for their own jurisdiction decision. And so the court has to be able to intervene. It's very welcome, in my humble opinion, to see Nigerian law really grappling with this issue, because the existence of the ART mechanism is a strong message that under Nigerian law, the position is that arbitrators, including the ART tribunal, can decide issues of jurisdiction. They can decide matters that go to the jurisdiction of the tribunal. And if the parties have agreed to use the ART mechanism, the court's residual jurisdiction to set aside awards is very limited. And the Act makes it clear that arbitrators and the ART tribunal are empowered to decide all of the issues that go to their own jurisdiction, and to decide issues going to the, for example, whether the arbitrator at first instance stayed within his or her mandate, which is another important matter that comes up very regularly in challenges. And that, I think, is an example of where this Act has been courageous, but also extremely helpful and providing a lot of clarity to parties potentially being involved in Nigerian arbitration. And I think we'll come on to talk about this a bit more, but the thrust of all of this is that insofar as parties have been or are reluctant to choose Nigeria as a seat of arbitration, the more clarity that could be provided in the Act itself, the better. So it's really good to see, from the point of view of encouraging international parties to choose Nigeria as a seat, it's really good to see this clarity being given in various respects in the Act. I hope I've done justice to your question, Princess. I'll stop there, but happy to return to the subject in due course if we have time.
Yes, you did great justice to the subject. Very well. Thank you so much for your contribution. And for me, what struck me most is the fact that this new Act actually meets international standards of arbitration laws. And aside this, the clarity provided herein will encourage a lot of entities, will encourage parties to choose Nigeria as the seat of arbitration. That is a plus for people practicing in Nigeria, for our colleagues, and also international practitioners as yourself. So thank you very much for the beautiful contribution. Please, can you tell us if there are any challenges and inadequacies or legislative loopholes in the Arbitration and Mediation Acts? And if they are, how would this change, how would these loopholes, how would they affect the arbitration landscape in Nigeria?
Thanks, Princess. And something I omitted to do when I spoke earlier was to apologize, first of all, for joining late, and to say hello to my very good friend Duncan, who I can see on the call. Thanks so much for joining us, Duncan.
Good morning. It's a pleasure.
Great. To answer the question, Princess, I think let me identify one that I think is a pure drafting error or a pure printing error, and that's the omission of what would have been section 57, I think, in the Act, which deals with interest. It was clearly the intention of the drafters of the award, of the Act, that for the first time, the legislation should make very clear provision on the power of arbitrators to award interest. I'm actually trying to see right now which section was unfortunately omitted. I think it's somewhere between 40 and 50, but I think when you look carefully through the draft, you'd find out that while the table of contents quite clearly evinces an intention that there will be a provision on interest, the power of the tribunal to award interest, in the substantive body of the Act itself, you don't see that provision. I think that's a printer's devil, and I think that's something that will be corrected when the legislation is being gazetted. So let me just to deal with that very quickly. What are the other issues that I think are gaps, obvious gaps? One was actually brought to my attention by Duncan when we were speaking earlier, at sometime last week, about the Award Review Tribunal. And that's the question: if the Award Review Tribunal decides to uphold an award, if it decides to set aside an award or uphold an award, what's the period of time within which you must go to a court to challenge the decision of the Award Review Tribunal? Now, no clear provision is made on that. And again, obviously, this probably, kind of signposts the need for a further review, probably by way of just an amendment to this this new legislation. There needs to be clarity on that. Or until such clarity is provided by the legislature, I think that it will be easy to fall back on a Supreme Court decision in which the 3 months period that was provided for in Section 29 of the old Act was also applied to Section 30 of the old Act, even though Section 30 did not contain a provision for 3 months limitation. Now, there's clearly a 3 months limitation provision for challenging the decision of the arbitral tribunal. That's the actual arbitral tribunal. And I believe it will be applied just like the Supreme Court did, in a judicial decision. The same approach will be applied, at least to fill the gap pending when there is a legislative amendment. Now, let me come to what I consider to be perhaps what, if you ask me, I wish we had done when we were looking at, when we were preparing the draft legislation. There will always be those moments when, if you're involved in law reform and you finally get what you want, there will be those moments when you realize, oh my goodness, I wish I'd put this there as well. And it's something to control the manner in which lawyers approach the courts in Nigeria to get injunctions to restrain pending arbitrations. Now, obviously, you cannot legislate to oust the jurisdiction of the courts. We've discussed that today already. But there's been a trend in which lawyers would say to you that once an application has been filed to court to restrain the arbitral tribunal from sitting, then the arbitral tribunal is constrained and cannot continue with the proceedings until the court has decided the application for an injunction to restrain the tribunal. Now, I've seen a number of arbitral tribunals actually succumb to that argument, not particularly where the panel consists of foreign arbitrators who really want to be very careful about the law of the forum. Nigerian arbitrators who are probably a bit more familiar with the terrain sometimes show a bit of a more daring attitude to those types of arguments. And they say, well, unless I'm served with a court order, I am not going to stop my proceedings. I think that is actually supported by law. There is a Court of Appeal decision involving Guarantee Trust Bank, not specifically in the arbitration context, but laying down a broad proposition that if you are contractually obliged to a third party, then you cannot, because a motion for injunction is served on you, not fulfill your contractual obligations. The only thing that would justify not fulfilling your contractual obligation is if you are served with an order. So, of course, as we all know, the arbitration process is a contractual arrangement between the tribunal and the parties. The parties enter into a contract by which they appoint the arbitrator. The arbitrator has a contractual obligation to the parties to conduct the arbitration in an expeditious and efficient manner. And so the arbitrator would be in breach of that contractual obligation if he or she decided to stop the arbitration simply because they were served with a motion of notice. And that will be covered by that Court of Appeal decision I mentioned just now. But obviously, it would have been great if there had been a provision making that very clear in this legislation, namely that arbitral tribunal does not stop its work, simply because it's served with a motion of notice. There are already provisions there which discourage courts from restraining arbitrations by injunction. And those provisions have even been strengthened now under this legislation. You would all remember the case of Statoil versus NNPC, in which the Court of Appeal held that it is not you have that provision that says that a court can only intervene in the manner allowed by the Act. And the Court of Appeal said it is not one of the manners of intervention allowed by the Act that a court should give an injunction restraining arbitration. That continues to be law. But to the extent that lawyers can still argue that, well, I have an application pending before the court for an injunction, and you must not do anything until that application is decided, there's still room for mischief. And I wish we had put something in this legislation to control that mischief.
Okay, thank you, Leonard Silk, for that wonderful contribution. And so, Mr. Isaiah, quickly, this question is for you. Now, what are the key introductions and the corresponding implications of the Act as regards mediation as a dispute resolution mechanism in Nigeria? Because it's not just the Arbitration Act, it's the Arbitration and Mediation Act. So we actually have a legislation on mediation now, thanks to this new act. What are those introductions and then their corresponding implications? Thank you.
Princess, thanks again. And Duncan, thank you for that very beautiful exposition. If you wouldn't mind, there's just one thing I'd like to pick up on what Duncan said before I move on to the mediation provisions, and that's regarding the enforcement of arbitration agreements. Critically important, because if you look at, for instance, surveys that point to what parties are looking for in a safe seat, they're not looking only to the law, but they're looking at the court's track record of enforcing arbitration agreements and enforcing arbitration awards. And the interesting question that Duncan raised is to how far will the courts go in determining whether an award is null, void, inoperable, or incapable of being performed. And interestingly, I think the case law in existence actually points to the fact that it should be a prima facie review. It shouldn't be a comprehensive review in the sense of not giving the arbitral tribunal an opportunity to make that determination on the competence. So for instance, if you look at decisions of the courts, Nigerian courts will uphold an arbitration agreement where the parties have an unequivocal intention to refer the dispute to arbitration. So the court said that in Mekunye and Imokwe, the Supreme Court. So the question is, what is an unequivocal intention? And there is interpretation for that in Fidelity Bank and Generose, where the court said that if the reference to arbitration is neither permissive nor discretionary, then that in and of itself is an unequivocal reference. And so long as the agreement conveys the party's intention to arbitrate, then the courts will uphold it. So I think at that stage, what they should be looking for is to say, well, is there an unequivocal intention to arbitrate? Is the arbitration agreement such that the reference to arbitration is mandatory? And the other requirements of the arbitration, if you look at the Eisman criteria, the other arbitrations are present. And insofar as they exist, then I think current Nigerian case law points to the fact that there should be a reference to arbitration. And that's really important, because the more decisions we get of these upholding the parties' agreement to arbitrate, the more competitive the seat becomes. because parties will then have that confidence to say, okay, yes, I can designate a Nigerian seat, knowing that the risk of the court interfering in the process is to the greatest extent minimized. So I just think that's a very important point to clarify, and I thank Duncan for bringing that up. Now, to the point on mediation, you're very correct. The Act, in addition to introducing very robust provisions on arbitration, also addresses mediation. And that's significant because it, for the first time, introduces a framework for mediation proceedings. So it gives very comprehensive guidance for the mediation proceedings from the beginning to the end, from the appointment of the mediator through to the enforcement of the settlement agreement. And I think for most parties, that framework for enforcement of the settlement agreement is the important one. And again, it aligns with international standards. Many of you will be familiar with the Singapore Convention for the recognition and enforcement of mediated settlement agreements, which pretty much is the New York Convention for mediation. Nigeria is a signatory to that. And from my understanding, the process of ratification, if it hasn't already been concluded, will very soon be concluded. But the fact that our national legislation recognizes that commercial mediation has a distinct framework and recognizes that the outcome of that process will be recognized by our courts, then I think, again, it gives confidence to the parties to engage in that process. Now, why is that important? It may not seem very obvious to many, but if you look at it from the perspective of the administration of civil justice, then it has very major implications. Let me give Delta State as an example, because that is a jurisdiction with which I am very familiar. Now, during my time as Attorney General, we adopted what Mr. Fagbohunlu started under an organization called, I think it's called ComThisLawNet. And what they did is to draft a model legislation for the administration of civil justice. And Delta State took that base model, had our own conversations to determine what we needed internally, and then built upon it and enacted it. Essentially, what that legislation does is to create a shift in the mindset from one of litigation to one of resolution. So it really sort of puts the question of access to justice under the microscope. And if I can give an example for this, there's a case I always love using. It's a case that was initiated in a year before I was born. I won't give away my date of birth, but a year before I was born, this case was initiated. And my parents were the initial lawyers that were fighting this case on behalf of the claimant communities. It was a case to do with oil spill. Now, fast forward 35 years later, a case that was initiated before I was born was concluded by me in the Supreme Court. So that process took one of 35 years from the inception of the High Court to conclusion at the Supreme Court. Yes, it's an extreme example, but if any of us have been in the Supreme Court recently, you know that the backlog of cases is increasing. So the thing we need to really think about is, what do we mean, or what is our intention when we raise this access to justice argument? And in fact, I heard a very interesting analogy that the problem in Nigeria is not access to justice or access to the courts. The problem is actually the exit from justice. You can access the courts very easily, but there is no guarantee as when you will exit. So increasingly, I think the conversation has to be, how do we create a shift in the mindset from one of litigation to one of resolution and everyday justice? And that's where provisions like the mediation provisions in the Act come in, and supplemented by legislation at the subnational level at each stage, at each state, with administration of civil justice laws. So what ours in Delta State does, is it encourages a constant dialogue between the parties inter se and between the parties and the court. So primarily between the parties, what it's doing is encouraging you, before you file your action, is to engage in active discussions to see if that dispute can be settled. And to the extent that you access the courts, then again, it's still nudging you to have that discussion. So what happens now is after you file your claim, in 30 days after you file your claim, the judge will then convene a case management meeting. In that case management meeting, you're required to fill in several documents, one of which is a case diagnostics form. In the case diagnostic form, the courts are asking you a series of questions to try and understand the nature of your dispute. For instance, is it something that can be resolved easily through ADR, and your questions will determine that? Or is it something that actually requires a judicial determination? Likewise, the courts will also fill something called a self-assessment diagnosis of the case. And again, the court is looking at whether there are factors that will encourage the settlement, either through mediation or another ADR process, or if it's one that requires a judicial determination. So increasingly, I think it's very necessary for us to have this conversation more and more, because the efficiency of court proceedings is one that will shape the dispute resolution framework in the country. It's one that will have implications internationally, because, for instance, if we undergo an ADR process and we have to engage the court's proceedings or the court's procedures to now either enforce or support that process, then what the party's legitimate expectation is that we will have the same level of efficiency in the ADR process as we do in the courts. But the way our court proceedings are organized at the moment, you might not have that efficiency. So typically what happens now is that you file your papers, they will adjourn for either mention, then they will adjourn for hearing without really actively managing the case. So what happens typically is that you might come and say, oh, my lord, my witnesses are not ready. Or, oh, my lord, something has happened that has affected my ability to proceed with these proceedings. So mediation and the shift in mindset is one we need to take very seriously. It's one that the bedrock will be laid by legislation, but much more than that, it's one that will take a lot of, I hesitate to use the word education, because I know some of us might not like it, but it's one that will take a lot of, let's say, dialogue between members of the bar, between members of the bar and the bench, and between the users of our dispute resolution mechanisms. Because the default, it seems, is that as soon as a disagreement comes up, automatically we want to approach the courts, and we don't think we can achieve a good outcome if we go through an ADR process such as mediation. So I think the introduction of mediation provisions in the Act is a very critical and important first step. I think it's only one piece of the puzzle. It's going to require additional arrangements to signify that mediation is a viable option in Nigeria, and that mediated outcomes will lead to more efficient resolutions of disputes. So again, I would encourage everyone here to look at those mediation provisions. It's under Part 2 of the Act. And I think it, again, sets the potential to really revolutionize our dispute resolution landscape in Nigeria. So Princess, I'll hand back to you unless there are any other areas regarding mediation you would like me to cover.
Thank you very much. That was explicit and really extensive. So quickly, Mr. Bagshaw, I'll show this question to you. What are the opportunities presented by the changes introduced in the Act? And how can lawyers professionally maximize these opportunities? Thank you.
Princess, this is an act which fundamentally makes Nigeria a place that should be considered by international parties as a seat of arbitration. That doesn't mean that it can be selected in every case. The process of choosing what provision to make in a contract for the seat of arbitration is a very subtle one. A lot of factors come into play. But fundamentally, before we get on to some more detailed aspects, the answer to your question is that with the benefit of this act in place, and hopefully with the support for the Act that we will see from practitioners, from jurists and commentators, and crucially from the judiciary, as Isaiah was saying earlier. With that support, there's no reason why having this Act in place can't make a significant difference to the extent to which Nigeria can resolve more disputes relating to Nigeria, involving parties from both within and without the jurisdiction, and potentially disputes which do not relate to Nigeria, but in which parties to a contract have chosen Nigeria as the seat because of the law that has been adopted, which meets the international standards, which most advisors of parties entering into contracts will require from any seat that they choose freely in entering into their contracts. So the first and fundamental point is that opportunities for lawyers arise when they are in a jurisdiction which is taking positive steps to make itself attractive for parties which might choose it as a place of arbitration. Secondly, there are some quite specific aspects of the law which represent opportunities for parties. One of those is that under the appeal review, the award review tribunal mechanism, clearly it is the case that a new creature is going to be created under Nigerian law, and that is the award review tribunal itself. That has the inevitable consequence, to the extent that it's taken up by parties agreeing to it in their contracts, because of course, as we heard from Isaiah earlier, it is an opt-in provision, so you do need to make express provision in the contract, in the arbitration agreement, that it will apply. When that is chosen, to the extent that there's any challenge to the award, a new role comes into being for arbitrators in Nigeria, which is that of award review tribunal members. Those tribunals, I think in many cases, will consist of 3 arbitrators, and therefore there will be a need and a call for experienced arbitrators who are suitable to be selected for the very important role which is undertaken by the ART tribunal in reviewing awards in Nigeria and from Nigeria, and that will, I hope, increase the opportunities for practitioners, and it will increase the opportunities to gain experience in an appellate role, which is extremely important. And we've heard questions today, including from Marx, about the extent to which the court's jurisdiction is ousted or limited. Now, I wholeheartely agree with what Isaiah and Tunde, the Silk, was saying earlier. This is not a matter of ousting the jurisdiction of the court, but it is a matter, I think, in Nigeria of supporting the arbitration framework and bringing more decisions within the jurisdiction of the arbitrators themselves. It's important to bear in mind here that by adopting this law, arbitrators are being supported in their jurisdiction to make decisions. The power of the court to intervene is narrowed. That's not to oust the jurisdiction of the court, it's just to limit the grounds on which it can intervene. So the importance of the role of arbitrators and ARTs under that mechanism is increased and reinforced. That supports the decision that the parties have made to choose arbitration, which is all to the good, but it also importantly underscores the importance of good, experienced arbitrators in Nigeria fulfilling this role. So that's very important as well. I would just mention as well the mediation provisions. I think there are some really interesting aspects of those. We might come back to them later, but just to mention, to pick up on a question that was asked earlier, it's very interesting, the point that was made about the fact that there's no provision in the Act which sets out the requirements for a mediation agreement itself, unlike an arbitration agreement. What the Act does do in section 91 is define what a mediation is, what mediation means. So that's a very helpful place to go to see what is meant by mediation. But I think it's important to remember that with a mediation, the process, unlike arbitration, the agreement really only becomes complete upon the conclusion of a settlement agreement. Because until that time, it's inchoate, it's not complete, because a mediation consists of a voluntarily engaged process by the parties. And although there can be provisions which require them to attempt mediation, until they reach a settlement, nothing becomes binding. And so mediation focuses on that end of the process. In arbitration, by making an arbitration agreement, you are committed to the resolution of disputes by the arbitrators. In mediation, until you reach your settlement, there is no compulsory resolution of disputes by that route. If the mediation fails because the parties don't agree, they fall back upon the substantive dispute resolution mechanism that they've chosen. So I think that's why it's less important for a law like this to set out what is required from a mediation agreement. What's more important is to set out what a mediation looks like and the effect of an agreement reached after a mediation, which the Act does quite comprehensively. But to relate this all back to your question, Princess, the answer is that the benefit of an Act like this, which really codifies mediation, it makes it part of the system. It also refers to and adopts the provisions in the Singapore Convention. The effect of that is going to be to focus the minds of parties on mediation as a process, which gives significant opportunity for lawyers to get involved in that, for mediators, professional mediators, to hone their skills, to apply them to what is likely to be a more structured and formal mediation process in order to help ensure that mediated settlement agreements are enforceable under the Singapore Convention. I have a question for my learned Nigerian colleagues, if I may, but it may be that we don't have time, but at some point, it would be very helpful to understand the extent to which the Singapore Convention is yet to be brought into force by Nigeria, whilst in the Act itself, there is the provision that purports, as from the coming into force of the Act, to apply the provisions of the Singapore Convention where mediated settlement agreements made in another state, which is a party to the Convention, come to be enforced in Nigeria. It's almost as if in some respects Nigeria has brought into law aspects of the Convention, even if as yet it hasn't been fully brought into force and ratified by the state. But I don't know whether that's a topic that we have time to discuss, but it's certainly an interesting one, I think, in this context.
Thank you very much, Mr. Bagshaw, for that wonderful contribution and the question. Can we say the Act has whittled down the powers of courts? For instance, with respect to the appointment of arbitrators, it specifically provides for two options for parties to ventilate their grievances to either the courts or arbitral institutions. This is also similar to the provision as regards challenge to jurisdiction.
Okay, thank you for that question, Rufus. Has it whittled down the powers of the courts? Well, I think, first of all, the first thing we need to understand is that when the parties choose to arbitrate, then they're making a conscious and contractual decision to remove their dispute from the court forum and presenting it before a private forum where the arbitrators will decide that the outcome of that dispute. Now, most, if not all, arbitration acts have a provision that limit the court's ability to, let me say, interfere with the arbitral process. So you will see something along the lines of, in matters related to this act, the court shall not intervene except where provided by this act. So in other words, the act will set out the scope through which the courts can assist the arbitral process. So regarding the appointment of arbitrators, for instance, if you find that the agreed procedure is not quite working, then you may bring an application before the court to assist you in that procedure. Yes, the Arbitration Mediation Act also allows you to bring that application instead of the courts to an arbitral institution. And the key reason is one of efficiency. Typically, what you had under the ACA, the Arbitration and Conciliation Act, is that all arbitration-related applications had to go through that formal motion of notice process. And depending on the efficiency of a particular court, that process could take a very long time. The Arbitration and Mediation Act solves that to an extent by saying that for such applications, a court means a judge in chambers. So you bring the application administratively through a letter rather than through a formal application. But it's just presenting the party with options to say, okay, if I want to submit that application to an arbitral institution, then I choose to do so instead of submitting it to a court. Likewise for setting aside or challenging the arbitration award. This one is very important because we have not done anything that departs from the international standards. So if you look at the Armstrong Model Law and the New York Convention, there is a closed list of grounds under which you can challenge an arbitral award. Likewise, if you look at Nigerian case law, it emphasizes that a challenge to an arbitral award is not a process through which the courts will take a fine-tooth comb and comb through the correctness of every single decision the arbitrator has made. What they will do is to look at whether the challenge fits into one of the permitted grounds under which you can set aside an award. So contractual capacity, due process, public policy, jurisdictional issues, whether you've exceeded the scope of your jurisdiction, et cetera, et cetera. So there has always been a limited scope of review. And so the question I'm sometimes asked as well is whether the Arbitration Act now constitutes an ouster to the court's jurisdiction. And the court, again, I've already answered that. So if you look at the decision of I believe it was the Supreme Court in Lack versus Air Atlantic, what it says is that an arbitration clause is not an ouster to the court's jurisdiction. So they will not interpret it in the same way as they will interpret ouster clauses. Likewise, if you look at the practice direction issued by former Chief Justice, the Honorable Justice Onogen, it's very clear that where the parties have included an arbitration agreement in their contract, and they then, in breach of that arbitration agreement, go to the courts, that is actually a breach of contract. And the courts, in upholding the arbitration agreement, should actually award damages for breach of the contract. And what is interesting about that practice direction is it goes even beyond the standard in what was then the ACA and the Arbitration and Mediation Act in terms of review. So what our act says is that the courts have a scope to make a prima facie review as to whether the arbitration agreement is null, void, or incapable of being performed. But what the Honorable Justice Onogen did in that practice direction is to say, as soon as you see an arbitration agreement, then you must decline. You must refer to arbitration. And that's more akin to the concept of negative competence that we'll see more akin to French jurisdictions, where as soon as they see an arbitration agreement, unless that arbitration agreement is manifestly void, then they will refer it to the tribunal. So in answer to your question, I don't think it whittles down the court's powers in the sense you're thinking, in the sense of an ouster. I think it recognizes and respects the parties' contractual choices. But like I say, much of it will be down to how the courts interpret these provisions. I noticed that Leonard SM, Mr. Fagbohunlu, has his hand up, and I suspect he may want to make a contribution to this question as well.
Thanks, Isaiah. And it was really just to support the points you just made, but from another angle. I hope you can hear me. Yes, from another perspective, and it's one I've always referred to when I talk about this subject. Let's just consider the principles of judicial review of administrative action. I'm sure many of us are familiar with the idea that when you apply to court to review the decision of a public law authority, you don't ask the court to review the merits of that decision. Rather, what you do is that you ask the court to consider whether certain due process, requirements have been met. And if they've been met, then you can't question the discretion of the public law authority. But if they've not been met, say for instance, if the public law authority did not give a fair hearing when making that decision, or if it acted irrationally in a way that no reasonable human being would have acted, or if it acted outside the scope of its powers, then the court can set aside the decision of a public law authority. But if the public law authority observed all these due process and jurisdictional formalities, then the court cannot intervene. This is what you call the limited scope for judicial review. Now, many of you will probably recognize the New York Convention grounds in those same parameters I mentioned just now. The New York Convention grounds are due process grounds. They are jurisdiction, their capacity, their due process, fair hearing, listening to the other side, not being a judge in your own cause, not having an interest in the arbitral process. So the New York Convention grounds are apparently, they actually almost mirror the same principles you have in the common law about the limits to which a court can review the decision of a public officer. Now, just imagine if the common law could limit judicial intervention the way it does in the context of public law authorities' decisions, then why can't statute also have such limitations, provided parties have agreed to act within the context of that statute? It has never been said in Nigeria that the common law principles that prevent a court from intervening to question the merits of a public law authority are unconstitutional. That's never been said before in Nigeria. It would be a startling proposition if anybody were to make that in a court of law. And if the common law could impose such restrictions that are recognized to be constitutional, then I submit that a fortiori statute can also legislate for those types of restrictions. And that's what's exactly the philosophy that underpins the New York Convention, arbitration legislation, and arbitration agreements, just to provide some additional conceptual firepower to the point that you made, Isaiah.
Thank you, Leonard Silk, for that wonderful contribution, and Mr. Isaiah for the clarity provided.
What are ways to be produce all the countries in one solution to produce agreement on the vessel on arbitration, on mediation and conciliation? What are international any treaty should be a follow-up for all countries should be a participation in one treaty? Like we have in our FUC, ICRC, we have the one treaty that there will be a work on the international treaty. But we have if you see in arbitrations, we have the no treaty should be a participation in our all the countries should be a participant in one country. If we have, I think so. What do you ways and what do your ideas in these factors into the agreement in these treaties?
Pradeep, if I understand your question correctly, you're asking to what extent should presumably African states be party to an international treaty?
Yes.
For the purpose of enforcing an arbitration agreement?
Yes, on the basis of an international agreement. But if it doesn't part of it, for example, Pakistan is not part of any treaty, why should we ways to be a follow up on this treaty-based system? If we haven't the part of it, should we have any policy? Should we have any laws and rules and regulation for the follow-up for these countries?
Yeah, okay, thanks, Pradeep. So, as Duncan mentioned earlier, there actually is an international treaty in place for the recognition and enforcement of arbitration agreements, and that's the New York Convention. Now, the New York Convention has certain conditions for when you sign up to it. You can have a reciprocity condition or a commercial condition. The reciprocity condition perhaps is applicable here. And what it says is that unless another country has also ratified the New York Convention, then you are not obliged to give effect to its provisions. But if you do not sign up to that reciprocity condition, then irrespective of the country in which an arbitration agreement is signed or under which law it's under, then you can go ahead and enforced. So in counting how many, maybe I think Professor Oyem is probably in a better position to answer this as to how many African states are signatories to the New York Convention. It's something I will check, but the vast majority of them are already signed up to the New York Convention, meaning there is already a framework in place for the recognition and enforcement of arbitration agreements. An interesting question actually is, for instance, related to third-party funding, in the sense that now that Nigeria recognizes third-party funding, if a Nigerian-seated arbitration occurs and third-party funding is involved, but the enforcement is in another African jurisdiction or another jurisdiction that doesn't recognize third-party funding, will problems arise as to its enforcement? And that's where we might start thinking about alignment of African arbitration laws. I know there is some conversation at the moment going ahead, and that's really been driven by Dr. Okubote, Abayomi Okubote, in terms of ensuring that African arbitration legislations are aligned for some of these more progressive provisions. So we don't have situations where one jurisdiction is progressive, but if there's enforcement in another jurisdiction, problems will arise. I don't know if I've answered your question 100%. I hope I have. But to the extent that you have a follow-up, please feel free to throw it in the chat or ask it orally. Really interesting question, because constitutionally, if you look at the provisions of the Constitution, it actually says that ratification of an international convention, from one reading of it, could take place by the enactment of legislation. Now, the conversation that has been going back and forth is whether the ratification it needs to be a formal act of the Federal Executive Council. And that's where the Federal Ministry of Justice fell. So when we were drafting, we looked at these provisions, and we read it as meaning that a state would ratify if its legislature brought about legislation that incorporated it. And in fact, if you look at the ACA, that's what it did with the New York Convention. So we were thinking it would be a similar process with the Singapore Convention, but the Ministry of Justice is insistent that the ratification must be through a formal act of the Federal Executive Council, and our understanding is that is well on the way, if not already completed. It's something that we'll have to check. In terms of what happens if it hasn't been ratified and your legislation provides for it, well, again, it's your legislation. So the position under Nigerian law is that the courts have a duty to give effect to Parliament's intention. And Parliament's intention in this case is to give effect to international or settlement agreements that come from a jurisdiction other than Nigeria. So presumably, unless there is a constitutional challenge to that provision, it stands as Nigerian law currently. I don't know if Leonard Esayan has any thoughts on that, but that's my thinking regarding your question.
So the first question I have here is from Raymond. Raymond Obare is saying, is the decision of the Award Review Tribunal subject to further review by the courts? If yes, what then is the logic behind the introduction of the tribunal?
Okay, so good question, Raymond. So interestingly, in discussing the introduction of the Award Review Tribunal, this was a question that came up a lot. And in the original draft, actually, there was no scope for further review. Now, the problem with that is there is a significant risk that provision will be struck down as being unconstitutional. Why? Because the Constitution guarantees you an access to the courts. So we were mindful of that. And now in the discussions, what then ensued is to say, okay, well, if the parties choose to go to the Award Review Tribunal, what is the scope for further review by the courts? We then limited it to two instances. And that's the one you will find under, if you look at the UNCITRAL provisions or the New York Convention provisions, under sub B, which is the one that offends the state, as it were. So they can only review it if, for instance, the matter was not capable of arbitration under Nigerian law, arbitrability. or if it's one that offends public policy. So it greatly limits it down to those two grounds for further review. The grounds under sub A are no longer up for review by the courts anymore. Is it the ideal scenario? No. The ideal scenario would have been one to say it stops at the award review tribunal. But again, the danger was that we will have that provision being struck down. And that's why I premised my initial engagement by saying that the Act alone will not achieve the intent. The Act is simply one piece that is already in place. For the award review tribunal to work as intended, two things are critical. Acceptance by the parties, will the parties even be willing to accept these provisions? And respect in terms of upholding the parties' contractual agreements by the courts. Will the courts recognize that this is a matter of party autonomy and contractual autonomy and respect that decision? So that remains to be seen, but that is why we need to have this engagement, not only within ourselves in the legal community, at the bar, but also extend the conversation to include the bench as well, to number one, understand what the rationale behind the ART mechanism is, and number two, to understand how to engage in a review if necessary, if an award has already gone through the ART process and then comes through and touches the court proceedings as well. Excuse me. I should also add that what the Act introduces in one of the schedules, I want to say Schedule 3, but I'll have to double check, is the arbitration procedure rules. And that's also another important introduction. What that does is similar to what you have in other proceedings like election petitions, is to introduce propose a time limit for the court to deal with arbitration-related applications. And again, it's going to come down to acceptance of those provisions. It's all well and good being there, but if the court looks at it and says, well, it is not a time limit introduced by the Constitution, therefore I do not have to respect it. What are we going to do? There's very little or nothing you can do about it. So the Act is a very good first step, but the what next is probably a more important question. What next in the sense of how are we going to ensure that it is implemented as intended? So Raymond, I hope that answers your question. Once it goes through the ART, the scope for further review is limited to issues of arbitrability and public policy.
First question is, the cost of arbitration is relatively more expensive than the regular court, making it difficult for small claims matters to be solved via arbitration. Does the new Act address this issue of cost of arbitration? Next question is from Max Ikongbe, and it says, thanks, Mr. Azaya, for the insights. I want to ask about mediation. While Section 2 provided very robustly for the form of an arbitration agreement, we don't see the same for mediation agreements. And secondly, does the Act touch on multi-tier clauses embedding mediation, followed by arbitration or other ADR forms?
Okay, so let me answer the second question first. The second question is no, it doesn't touch on multi-tier clauses. Now, to the first question, why are the provisions not as robust for mediation as they are with arbitration? I think we have to also be careful in not being overly formalistic. So if you lean towards more legislative regulation of a process that's supposed to be as flexible as mediation, then there's a danger that in reality, it actually hinders rather than aids the process. I think what is important is for the most important thing is for the Act to give a framework for where the parties' agreement is not quite as complete or comprehensive. So it assists you in terms of, okay, how many mediators? How do you appoint them? How do you enforce your mediated settlement? What happens to the limitation periods? if you engage the mediation process. All these things, you will find them in case law, but it's what the Act does is to now codify those very important aids to the mediation process, as it were.
If the arbitration procedures discourages the interference of regular courts, and there seems to be an open-ended approach to compliance of the outcomes of arbitration, what makes arbitration process more attractive to regular court practice? To rephrase that, I think he wants to say, what makes arbitration more attractive than litigation, that is regular court practice, putting the high cost of arbitration in view?
It is important not to over-regulate, such as that it will then remove from the flexibility of the mediation process, which to the greatest extent possible should be in the hands of the parties, and ensure that there is flexibility to tailor the mediation in a way that best suits the nature of your dispute. Don't forget, mediation will cut across a very broad range of disputes, whereas commercial arbitration is fixed to commercial transactions. Mediation might not necessarily be a commercial transaction, and it might be something that is just requires what I like to call everyday justice. I'll give you an example. There are disputes that I see where what is really driving it is the parties' egos. All it will take is for one person to say, listen, I messed up, I'm sorry about that, let's move on. And if you're going to mediate that sort of a dispute, you do not need an overly complex process. You need to keep it as flexible as possible. So that's one reason we did not want to be overly formalistic as regards mediation in comparison with arbitration.
From Samuel Obaka, it says, please, I need a clear interpretation of Section 34 of the Arbitration and Mediation Act 2023 on the application of statute of limitation to arbitral proceedings. Does it apply?
Yes, I'm very happy to offer some brief comments subject to your knowledge of Nigerian law, obviously, which I defer to. But I would, in relation to the question of cost, it's in the nature of arbitration that the feature of arbitration which is most helpful in terms of cost, or the features, are firstly the flexibility of the process, so that in smaller cases it should be possible for arbitrators to feel empowered to adopt procedures which are simple and rapid and efficient. And generally speaking, what you want from an arbitration act is a law which protects the arbitrator's freedom to adopt those kind of procedures, and so to help control the cost of an arbitration. This law does that in various respects. One is the very simple mechanism in Section 6 that says if there's no agreement to the number of arbitrators, there will be only a single arbitrator, which is obviously less costly than having a panel of 3 arbitrators. The other ways in which this is done is to limit the grounds for challenge to awards, which I hope will give arbitrators reassurance when they're sitting in Nigerian seated arbitrations, that they do have the freedom to adopt robust procedural measures to control the costs, for example, by limiting the scope of document production, by controlling the length of hearings, by holding hearings virtually rather than physically, and by controlling the length and breadth of submissions that parties make, by limiting, for example, the length of written pleadings and written submissions, and also identifying the issues to which the submission should be addressed. So that's really what arbitration does to control costs. It gives the arbitrators the freedom to make decisions to seek an efficient resolution of the process. The only other thing I'll mention before I give way to the professor is to say, in relation to the question of what makes arbitration more attractive than regular court proceedings, I think it's important to note that when you seek the support of a court for an arbitration process, you hope that although the court intervenes only to the extent required to support the arbitration process, it should still hopefully do so robustly. So that means that if you seek interim relief from a tribunal and you need to ask a court to enforce it, hopefully the court, without embarking on a complete revision of the interim relief, will enforce the decisions that the arbitrators make, so that your chosen forum is protected from undue interference by the courts. And at the end of the case, when you seek to enforce an arbitration award, hopefully the courts will rapidly and without substituting their own decisions, enforce the decisions that the arbitrators have made. So I entirely understand the question about the limited intervention of courts and whether that means that they'll take a non-interventionist approach. I think it means that they will generally hold back from interfering with the arbitrator's decisions, but at the same time be robust about supporting the process and enforcing the arbitrator's decisions. So hopefully that retains the attractiveness of arbitration as compared to court proceedings.
Thanks, Duncan. And I guess, I think you've pretty much, said the thoughts in my mind as well. I will add as little as I possibly can on the question of cost. The one aspect I'd want to speak to is the reference by the person who asked the question to small claims, because the Act actually does contain provisions on costs. As of today, one very important attraction of arbitration is that in arbitration, you can actually recover your costs in full, whereas in litigation, the way it currently is done, probably with the exception of a few states like Delta State that recently reformed their civil procedure, civil justice regime. For many other states, costs continue to be totally, the kind of costs that the courts award bears no reference at all, no relevance at all to the actual costs that the parties incur. But the Arbitration Act and arbitration itself as a process is one that ensures that parties are able to recover the full costs. In other words, the party who is entitled to costs is able to recover the full costs that it has incurred, including the full amount of, or at least a reasonable amount of its counsel's fees, as well as other expenses. So that's one advantage that arbitration as a process has over litigation. But coming to the point of small claims, I do understand, particularly in an economic environment in which you're having a lot of startups that typically do not want to commit any significant part of their budget to resolving disputes, to litigating or arbitrating disputes, or in an era where you're trying to encourage small and medium enterprises. The question, of course, is how can these types of businesses take advantage of arbitration as a mechanism? Today, there exists, court-attached ADR mechanisms, multi-door courthouses. In many of the major jurisdictions in Nigeria, you have a court-annexed ADR system that also offers arbitration. And I do know that they offer arbitration at significantly reduced costs to support small and medium enterprises, to support startup businesses. LASIAC, that's the Lagos Chamber of Commerce International Arbitration Center, also has a scheme to support small and medium enterprises. And so I think if you are looking to, have the benefits of arbitration for small claims, then you should look to these types of institutions, the multi-door courthouses and arbitral institutions like the Lagos Chamber of Commerce International Arbitration Center. So that's what I'd say in addition to what Duncan has said on costs. Does the Arbitration and Mediation Act repeal the Arbitration and Conciliation Act? Yes, it does. It does so, I think, in section 90, where it says the Arbitration and Conciliation Act of the Federal Republic of Nigeria 2004 is hereby repealed. So there is a clear repeal. But of course, there are transitional provisions. And I saw another question on the chat, which I don't think Princess read out, that asks does this new act immediately apply to existing? I think it said existing arbitration agreements or existing arbitrations, and I think you'll see from the transitional provisions there that no, this act is meant to apply to arbitration agreements that are formed after the act comes into existence, as far as arbitration agreements are concerned. And then I think to arbitrations commenced after this act came into existence. A lot will depend, of course, on the clause, because if the clause if the arbitration agreement in question says the Arbitration and Conciliation Act of 1988 or any law replacing it, then this enactment will apply. But if it merely says the Arbitration and Conciliation Act of 1988, then I think the courts are likely to say, notwithstanding the enactment of this new legislation, because the parties contract to apply the old legislation, then the old legislation will apply. Someone needs to mute their phone. The old legislation will apply. So a lot will depend. I think there's going to be an interplay here of the transitional provisions in the new legislation and the provisions of the contract that you are dealing with. It's potentially a minefield. And I think it's one that lawyers have to. I think the important lesson here is when you're having to deal with any question as to whether this act applies, look at the transitional provisions as well as the contract that you are dealing with, the particular arbitration clause you are dealing with to answer that question. Section 34 on limitation. The only significant change that was made on limitation was to overrule the rather absurd decision in city engineering. That was the decision that essentially said that time continues to run. Time, of course, starts to run from your cause of action, but it continues to run even when you are pursuing arbitration. So even when you've started arbitration and you are pursuing arbitration, time continues to run. That's the major mischief that the reform of Section 34 did. And what it essentially did was to say time is suspended from the point you commence arbitration. So I've had people say that what the new act does is to say time begins to run from when the award is given. No, that's not correct. Time does not begin to run from when the award is given. Time always continues to run from when the cause of action arose, except that time is suspended during the period that you commence arbitration. Then my last point I want to deal with is the question about the open-ended approach to compliance with arbitration outcomes. With due respect, I beg to differ from the person asking the question. I think that characterization would have been correct if this was a reference to the regime under the 1988 Arbitration Act, the old Arbitration and Conciliation Act. Yes, indeed, one could properly describe compliance with outcomes as being open-ended in the sense that there was a very wide scope for the losing party to reopen the merits in a court of law and do that all the way up to the Supreme Court. But under this new legislation, that scope has been significantly whittled down, if not completely eliminated. As Duncan had said earlier, we now have grounds of challenge that are limited to the strict grounds that are contained in the New York Convention. In other words, the merits can never be reopened. You can only raise questions, and I usually categorize them as three: capacity, jurisdiction, and due process. That's how I usually summarize the New York Convention grounds. And that's exactly what you have in this legislation. So unless your award debtor is able to legitimately raise a question that has to do with the jurisdiction of the tribunal, the capacity of one of the parties, or the extent to which due process was followed, unless they are able to raise those types of issues, an award will stand on the merits that it was decided by the arbitral tribunal. So it's no longer open-ended. And I think that provides a lot of justification for commercial people to continue to prefer arbitration over litigation, in addition to all the other reasons why commercial people typically tend to prefer arbitration. One very critical aspect of which is technical expertise, subject matter expertise. Arbitration continues to be an important method for resolving disputes. And in a world in which you are seeing a lot of technology-based contracts driven by cryptocurrency, in a world in which you are having to deal with very complicated questions like compliance with carbon limitations under the Paris Agreement and all of that, I think the specialist nature of commercial disputes will only continue to become more specialist and sophisticated, and arbitration will continue to be a very critical mechanism for resolving disputes. Thank you.
Is just to thank again the Garki branch for inviting me. It's been a very interesting discussion. I wish I could stay and continue, but at this stage, I'm afraid I have to drop off, and I look forward to watching the recording of the rest of the session as it plays out. So thank you very much again, and I wish you all full deliberations.
Thank you for finding the time to join in and for the very insightful contributions and expositions you made.
Thank you, Princess, and it's been a great pleasure being part of this discussion. I want to thank you for inviting me to speak. My quick closing remark will be this. I think this legislation will be just as good as the lawyers and the judges who implement it. Let's bear one thing in mind. This legislation is very liberalist in the sense that it's kind of opened up arbitral practice in Nigeria to the entire world, which is a good thing. That's a good thing for your seat, because one of the things that make a seat very unattractive is that you can only engage lawyers in the indigenous, in the local population for your arbitrations. But now that's been done away with. So Nigeria is competitive now, and Nigeria so now Nigerian lawyers have to compete for Nigerian seated arbitrations. That's something we need to bear in mind. But in that kind of competition, from that competition would emerge, from my perspective, the strengthening of skills and values within the Nigerian legal profession. I would advise lawyers to particularly study the third schedule to the Act, the Arbitration Proceedings Rules. Let's bear in mind, arbitration is now specifically governed by a specialist set of rules that expects that arbitral proceedings will be concluded in courts of first instance within 3 months to 4 months, and in appellate courts within 9 months in each appellate court. That's the objective, and that's the kind of rules that are in the third schedule. But if lawyers don't activate those provisions, they will probably be dead later. I had that experience in Ekiti State, where we had the civil justice, indeed, in all the states in the few states that have now passed the Civil Justice Reform Bill, the efficacy of the reform is dependent entirely on the use to which lawyers make of the new provisions, of the innovations. So lawyers need to be mindful of the third schedule and to please ensure that they activate those provisions in their daily practice. Thank you.
Thank you, Leonard Silk. And I'm giving a virtual round of applause. So please take it away, Mr. Duncan, your closing remarks.
I'd like to say 3 things. The first is to congratulate all of those who were involved in drafting the law, and crucially in securing the support for it necessary to have it passed and brought onto the statute books. I know these things can be very arduous and sensitive matters, so I do congratulate everyone who was involved, including the Learned Silk and anyone else on this session who was involved in it. The second point I'd like to make is that in addition to the importance of the role of the judiciary that has been emphasized, equally important is the role of the profession in discussing, understanding, studying and debating the provisions of an act like this. This is an important act because it adopts international standard, but it also goes further. So you have some unique and novel provisions which will need careful consideration and discussion, and the implementation of the act will be best supported if the profession as a whole engages with the consideration of its provisions. So I encourage that, and I encourage engagement with people like me and other lawyers who are not Nigerian and don't claim to be Nigerian law scholars, but who can offer a third-party view, an outside view on the provisions of the law, and hopefully engage in enjoyable discussions about it. Finally, I would just like to say thank you very much for inviting me to join this panel, and it's been an honor to speak alongside such learned speakers, so thank you.
Thank you, Mr. Duncan. And yes, your virtual round of applause. Really, we're truly grateful to the panelists for taking out the time. Mr. Duncan and Leonard Silk, and also Mr. Isaiah, who is not here now, for taking out the time to join us for this webinar and also sharing insightful knowledge to us and enriching us. We're better off than when we joined the webinar at the beginning. Thank you so much. Thank you so much for joining, everyone. And please do have a wonderful day and a wonderful weekend.
Thank you.